In Arizona, home sellers are legally obligated to disclose any known pest infestations or issues that could materially affect the property's value or desirability. This requirement is part of the Residential Seller's Property Disclosure Statement, SPDS, which aims to inform buyers about the property's condition. Pests that must be disclosed. Sellers must disclose any known presence or history of the following pests: termites and wood, destroying insects, any past or present infestations, treatments, or damage caused by termites or similar pests must be disclosed. Scorpions. Given their prevalence in Arizona, any known presence of scorpions on the property should be reported. Rodents and reptiles. Sellers should disclose any issues with rodents or reptiles, as these can impact the property's desirability. Bees and bee swarms. Any history of bee infestations or swarms should be included in the disclosure. Bedbugs, known infestations, past or present, must be reported to potential buyers. Disclosure guidelines. Honesty is crucial. Sellers are required to disclose all known material facts about the property, including pest issues, even if not directly asked by the buyer. Documentation. Providing records of pest treatments, inspections, or warranties can help substantiate disclosures and protect against future disputes. Legal implications. Failure to disclose known pest issues can lead to legal consequences, including potential claims of fraud or misrepresentation. Best practices for sellers. Complete the SPDS thoroughly. Ensure all sections related to pest infestations are filled out accurately and completely. Update disclosures as needed. If new pest issues arise before the sale is finalized, update the disclosure documents accordingly. Consult professionals. If unsure about the presence or history of pests, consider hiring a licensed pest control professional for an inspection. In Arizona real estate, material facts related to pest activity are any facts about pest infestations, damage, or treatment that could reasonably influence a buyer's decision to purchase a property or the price they are willing to pay. Material facts related to pest activity may include active infestations of termites, scorpions, rodents, bees, bedbugs, or other pests, evidence of past infestations that cause damage to the property, e.g., termite damage to wood structures, rodent droppings in insulation. Previous pest treatments, especially if recurring or related to structural pests like termites. Warranties or ongoing pest control services tied to the property. Hidden damage from pests that may not be visible but has been disclosed to the seller, e.g., behind walls or in crawl spaces. Why this matters. Under Arizona law and the Seller's Property Disclosure Statement (SPDS), sellers are required to disclose all known material facts. If pest issues are known but not disclosed, it could lead to contract disputes, claims of fraud or misrepresentation, financial liability for repairs, or remediation after the sale. In short, if the pest issue could impact the value, safety, or desirability of the home, it's a material fact and must be disclosed. By adhering to these disclosure requirements, sellers can facilitate a transparent transaction and minimize the risk of post-sale disputes. A seller must be responsible for disclosing treated or past infestations because it is a legal and ethical duty to disclose material facts that could affect a buyer's decision to purchase the property or negotiate its price. Pest infestations, especially structural ones like termites or rodents, can cause significant hidden damage, impact property value, and create future repair costs for the buyer. Here's why disclosure is required. Legal obligation under Arizona law. Arizona real estate law requires sellers to disclose all known material facts. This includes past or treated infestations, which may have caused damage or required structural repairs. Failing to do so can lead to lawsuits for fraud, breach of contract, or misrepresentation. Transparency protects all parties. Disclosing past infestations builds trust between seller and buyer and avoids surprises during the inspection period. It also allows the buyer to make informed decisions about inspections, repairs, and price negotiations. Infestations can have lingering effects. Even if the infestation is treated, damage may remain, e.g., weakened wood framing, rodent nests in insulation, or recurring bee activity. Buyers have a right to know the full condition of what they're purchasing. In short, disclosure helps prevent future disputes, supports a fair transaction, and keeps the seller in compliance with Arizona Department of Real Estate rules and standard industry practices. In Arizona, a seller must disclose any material facts they are aware of regarding pest issues involving neighbors or the HOA, but only if those issues could reasonably affect the value, enjoyment, or use of the property being sold. Here's what sellers should disclose. Neighbor pest issues, material if they affect the property. A seller should disclose known pest activity on neighboring properties if it impacts or could impact their own home, such as recurring infestations, e.g., termites, rats, scorpions, that cross property lines. Shared walls or structures, like in townhomes or duplexes, may allow pest migration. Beehives, wasp nests, or aggressive animal activity next door that affects safety or livability. Any pest problems that have already entered the seller's home from a neighbor's property. Example: if rats from a neighbor's yard have been entering the seller's home or garage, that's a material fact the seller must disclose. HOA pest notices or treatments. If the Homeowners Association HOA has issued notices or warnings about pest infestations, hired pest control services to treat common areas, required the owner to take action, e.g., treat for termites, clean up to prevent rodents. These must be disclosed, especially if there are ongoing issues, special assessments, or scheduled treatments. Best practice: disclose anything you'd want to know if you were the buyer, especially written notices from the HOA about pest problems. Any HOA pest control treatments billed to the seller. Neighbor infestations that have already affected the seller's property. Wheel title. These must be disclosed, especially if there are ongoing issues, special assessments, or scheduled treatments. Pro tip for agents and sellers: check the Arizona Seller's Property Disclosure Statement, SPDS, Section 4, Environmental Information, and Section 6, Other Conditions and Factors, which may prompt disclosures about pests, HOA matters, and neighborhood concerns. Note that a buyer may not be financially able to procure a loan if the HOA is too high or if there is an assessment that would be due upon close. The buyer may not have the funds for that expense. Make sure to call the HOA to find out all the costs associated with the transaction and transfer to the buyer during the inspection period. Here are some real-life cases illustrating the legal consequences of failing to disclose pest infestations in real estate transactions. Hill v. Jones, Arizona. In this landmark Arizona case, the sellers failed to disclose prior termite damage. The buyers noticed rippling in the flooring and inquired about termite issues, but the sellers denied any problems. After purchasing the home, the buyers discovered significant termite damage. The Arizona Court of Appeals ruled that termite damage is a material fact requiring disclosure, especially when the buyer has made specific inquiries. Ameris Sun City Pest Control and Atomic Bee and Pest Control, Arizona. Customers of Ameris Sun City Pest Control had purchased long-term termite warranties. After Ameris sold its assets to Atomic Bee and Pest Control, customers were told they had to pay a $125 activation fee to continue their prepaid termite inspections. Those who didn't pay were left without service. The Arizona Attorney General's office intervened, resulting in a consent judgment requiring both companies to pay at least $100,000 in restitution and honor the original warranties without additional fees. Undisclosed termite damage. Discovered post-purchase. A home buyer purchased a property and later uncovered extensive termite damage during renovations. The seller had not disclosed any termite issues, and the home inspection failed to detect the infestation. The buyer faced significant repair costs, and considered legal action against the seller for non-disclosure. This case underscores the importance of thorough inspections and the seller's obligation to disclose known issues. Stoff v. Bartnick, Oklahoma. In this case, a buyer sued both the seller and the real estate broker for failing to disclose known defects, including termite problems. The broker had prior knowledge of these issues from an earlier transaction, but did not disclose them due to company confidentiality policies. The court ruled that such policies do not override the duty to disclose material facts, allowing the lawsuit to proceed. 5. Etzenhauser v. Burke et al., Arizona. Etzenhauser purchased a home near the Santan Mountains and later discovered significant earth fissures causing structural damage. She alleged that the sellers and their agents knew about these issues but failed to disclose them. The lawsuit claimed breach of contract, fraud, and negligent misrepresentation. While not a pest-related case, it highlights the broader principle that sellers must disclose known defects that materially affect property value. These cases demonstrate the critical importance of full disclosure in real estate transactions. Sellers are legally obligated to inform buyers of known issues, including pest infestations, that could affect the property's value or desirability. Failure to do so can result in legal action, financial penalties, and damage to reputation. In Arizona, several laws and regulations govern the disclosure of pests in real estate transactions. These rules are designed to protect buyers by ensuring they receive accurate information about a property's condition, including pest-related issues that could affect its value, safety, or desirability. Here's a breakdown of the key legal frameworks. Arizona Revised Statutes, ARS. Paragraph 32, 2156, Disclosure Obligations. Requires sellers and their agents to disclose all known material facts about a property. A material fact is anything that could influence a buyer's decision to purchase or the amount they're willing to pay. This includes current or past pest infestations, pest-related damage, or treatments, especially termites, scorpions, bedbugs, rodents, and bees. ARS, paragraph 32, 2181.02, Subdivision Disclosure Report. Developers and subdividers must disclose environmental hazards, including conditions like termite infestations or past pest control issues, in public reports. 2. Seller's Property Disclosure Statement, SPDS. A form developed by the Arizona Association of Realtors, commonly used in residential real estate transactions. Section 4, Environmental Information, and Section 6, Other Conditions and Factors, specifically ask about pest infestations, past or present, pest control treatments, termite damage or warranties. Sellers must complete this form honestly and to the best of their knowledge. Failure to disclose can lead to legal liability. 3. Arizona Department of Agriculture, Pest Management Division, governs licensed pest control companies and the reporting of inspections and treatments, especially for termites. Requires pest control companies to issue wood-destroying insect reports, WDIIRs, for certain transactions. These reports are often required by lenders during escrow. 4. Common law duties, case law. Arizona courts, e.g., Hill v. Jones, have established that failure to disclose known pest damage, especially when asked directly, is fraudulent and can void a contract or result in damages. Sellers and agents can be held liable for fraudulent misrepresentation or concealment if they knowingly fail to disclose pest issues. Summary of disclosable pest issues. Sellers are legally required to disclose if they know about current or past infestations, termites, scorpions, rodents, bees, bedbugs, structural damage caused by pests, pest control treatments or ongoing service contracts, termite warranties, pest issues in shared walls or neighboring properties, e.g., condos, townhomes, pest issues noted or treated by the HOA if a buyer discovers scorpions or any other pest infestation inside or outside the home after the closing and the seller did not disclose the infestation, The buyer may have several options for recourse, depending on the specifics of the situation and local laws. Review the seller's property disclosure statement, SPDS. If the seller failed to disclose the scorpion infestation on the SPDS, the buyer may have grounds for legal action. Under Arizona law, the seller is required to disclose any known pest infestations or material facts that could affect the property's value or desirability. Contact the seller or agent. The first step would be for the buyer to contact the seller or their agent and notify them of the undisclosed pest issue. In some cases, the seller may be willing to remedy the situation, especially if they made an honest oversight. File a complaint with the Arizona Department of Real Estate. If the buyer believes the seller intentionally failed to disclose the infestation, they can file a complaint with the Arizona Department of Real Estate, ADRA. The ADRA investigates claims of fraud, misrepresentation, or failure to comply with disclosure laws. Legal action for misrepresentation. If the seller knowingly withheld information about the scorpion infestation, the buyer may be able to file a lawsuit for misrepresentation, fraud, or breach of contract. In such a case, the buyer could seek damages, which may include the cost of pest control, damage repair, and any related costs. The buyer might also seek to rescind the sale or negotiate a reduction in the purchase price. Negotiating a resolution. If the issue is discovered shortly after closing, the buyer may try to negotiate a resolution with the seller, such as the seller covering the cost of pest control or repairs. If the infestation is extensive, this could also involve negotiating a financial settlement or revisiting the purchase terms. Insurance. Depending on the buyer's insurance coverage and the specifics of the pest infestation, it may be possible for the buyer to file a claim under their homeowner's policy. However, many homeowner policies do not cover pest infestations, so the buyer should review their policy carefully. Post-sale inspections. After closing, buyers have the right to inspect the property, and sometimes pest-related issues might not be fully apparent during the initial inspection. If the pest problem was significant, the buyer may want to have a pest control professional inspect the property to assess the extent of the infestation and recommend a plan of action. Possible legal actions. Fraud or misrepresentation. If the seller knowingly failed to disclose the scorpion infestation, this could be grounds for a fraud claim, which might result in financial compensation or the cancellation of the sale. Breach of contract. If the pest issue was significant enough to alter the terms of the sale, the buyer could argue that the contract was breached by the seller's non-disclosure, and they may seek a legal remedy through the courts. Conclusion. If a buyer discovers scorpions after closing and the seller did not disclose the infestation, the buyer has legal options, including negotiation, filing complaints, or pursuing legal action. Arizona's laws mandate full disclosure of known issues, and the seller's failure to disclose such material facts can have serious consequences for them. Buyers should consult with a real estate attorney to explore the best course of action based on their specific situation.